Trump keeps losing in court, but the important part is not just that the administration keeps taking legal losses. The important part is why those losses keep happening. Because when you look at the cases together, a pattern starts to show up. The administration acts first, claims broad executive authority, and then federal judges come back with some version of the same question. Where did Congress actually give the president the power to do this? That is the part that matters. A lot of modern politics is built around the idea that the president can just move, sign the order, declare the emergency, create the fee, shift the money, punish the opponent, reward the ally. And then after the power has already been used, everybody else can fight about whether it was legal. That is not new. Presidents from both parties do this. Every administration wants more room to move. Every White House thinks its emergency is different. Every side convinces itself that the shortcut is justified because the cause is important enough. But the problem with shortcuts is that they do not disappear when the other party takes power. They become precedent. That is why these court losses matter. Take the $100,000 H-1B visa fee. The administration framed it as an immigration policy, a fee, a tool to discourage abuse of the visa system and pressure companies that rely on foreign workers. But a federal judge in Boston looked past the label and focused on what the payment actually did. If the government charges $100,000 to change behavior, that starts looking less like a normal administrative fee and more like a tax. And taxes are supposed to come from Congress. That is the pattern. The label says one thing, the power underneath says something else. The same kind of fight showed up with tariffs. Trump used emergency authority to impose sweeping tariffs, arguing that trade deficits and foreign economic pressure justified action from the White House. Supporters saw that as a strong economic policy. Critics saw it as the president using emergency language to bypass Congress on one of Congress's core powers, and the courts pushed back on that too. The question was not whether trade matters, it was not whether China matters, it was not whether the economy matters. The legal question was narrower, but much more important. Did the law the administration relied on actually give the president that kind of tariff power? Because if the answer is no, then the rest of the argument does not fix the problem. A policy can be popular, aggressive, or politically useful and still exceed the authority behind it. And just this week, the anti-weaponization fund hit the same wall. Supporters framed it as a way to compensate people who said they were targeted by a weaponized government. And in theory, government abuse is a real issue. Nobody should want federal power used as a political weapon. But that is exactly why the structure mattered. Critics saw the fund as something much darker, taxpayer money being routed into a politically controlled payout system for people aligned with the president's narrative. And federal judge Leonie Brinkema extended that block indefinitely on June 12th, keeping the administration from moving forward with the fund. Again, the question was not just whether someone could make a sympathetic argument for the policy. The question was whether the executive branch could actually build and control that kind of payout system this way. That is the through line. Fees, tariffs, funds, executive orders, agency conditions. Different policies, same pressure point. The administration keeps treating executive power like it can fill whatever gap Congress leaves behind. But courts keep asking whether that gap is permission or a limit, and that distinction matters. Because if presidents can create taxes by calling them fees, impose tariffs by calling them emergencies, build payout systems by calling them settlements, and reshape policy by attaching conditions to federal money, then Congress becomes less of a lawmaking branch and more of a suggestion box. That might sound useful when your side controls the White House. It will not feel as useful when the other side does. That is the part people usually miss. Executive overreach is not only dangerous when the person you dislike is doing it, it is dangerous because every shortcut becomes a tool for the next administration. Once one president proves the move works, the next president does not need to invent it. They just need to aim it somewhere else. So no, this is not just a video about Trump losing court cases. The bigger story is that federal courts are testing how much of the presidency still has to run through Congress, how much power still has to be authorized before it gets used, how much of the law is still law, and how much of it has become paperwork written after the decision was already made. That is the real fight underneath the headlines, not Trump versus judges, not Republicans versus Democrats. the presidency versus the limits placed around it. Because once a president can move money, create penalties, reshape markets, and punish enemies without Congress, the law stops being the source of power. It becomes the excuse written afterward.